It's my great pleasure to introduce next my partner, John Worden. John is a seasoned trial lawyer with Schiff Hardin San Francisco office, and he also leads our firm's Nevada practice. John has tried approximately 4 dozen cases, winning his last 20 trials and binding arbitrations. So he's pretty good at what he does. He's on the board and executive committee of the San Francisco Bar's Volunteer Legal Services Program. And in his spare time, John fights as a black belt kung fu instructor. He is a former silver medalist at the 2000 World Kung Fu Championships in Sao Paulo, Brazil, and is the current sparring partner for 2 reigning full contact world champions, which will, I'm sure, be incorporated into his presentation. Here to grapple with the issues of pro bono service, please welcome John Worden.
A few years ago, Julie Ray Harper lay in bed at night in her bedroom in a small town in Illinois. An intruder broke into the house, took a knife from the kitchen, went to her son Joel's bedroom, brutally stabbed him to death. Julie heard the screams, went to the son's room, found the intruder there. He beat her and ran off. Unfortunately, even though everyone agreed Julie was a great mother, the prosecutors always suspected her. Who breaks into a house where they don't know, without a murder weapon, doesn't take anything, kills someone, and then runs off? In an emotionally charged trial, the prosecutors, in fact 3 of them, ganged up against one public defender. In a trial that included evidence, for example, by her ex-husband testifying that Julie, when she was pregnant with Joel, considered aborting him, things like that. Jury heard a lot of testimony, found Julie guilty, sentenced her to 65 years in prison for a crime she didn't commit. Next gets involved is Ron Safer, actually a partner of mine. Ron Safer gets involved and leads a team that finds out from an author who had learned about the story that there was a serial killer in Texas named Tommy Lee Sells who committed crimes just like this murderer did. They took that evidence, contacted Sells, who was on death row in Texas, got him to confess, but even though 53 points of corroboration between what he said and what happened were confirmed, the prosecutors still believed Julie was the murderer. The pro bono team got a second trial, a tough trial with 40 witnesses called, and got her acquitted. So instead of Julie spending 65 years, essentially a life sentence in prison for the murder of her own child, she was free, and rightfully so. That's what we lawyers do. We do things no one else can do. I cringe when I hear the comments people make about us, the jokes. And they go on and on. Sometimes we do it to ourselves. There is a very highly publicized case in the papers right now about a firm that will remain nameless that may or may not be defunct, that sent a few emails around about a client's bill. By and large, though, lawyers do things no one else will do. Listen, I've been practicing for 25 years. I've never lied to a client. I've never defrauded a client. I've never churned a bill. I've never stolen anything. And yet we constantly have these jokes, these perceptions that lawyers don't do anything except make themselves money. Even Shakespeare gets in on it. The first thing we do, let's kill all the lawyers. Now, this quote, though, is a perfect transition to what I'm here to talk about. If you read Henry VI, and I know we all read it regularly, Henry VI, this line comes from a situation where some people were planning to overthrow a just government, impose themselves as dictators, take away all the civil rights of the people, and they said, if we're going to take away the civil rights of all, the first thing we have to do is get rid of the lawyers. Lawyers have done so much in this country. We founded this country. We wrote the Declaration of Independence, the Constitution. Lawyers freed the slaves, drafted the Civil Rights Act. I could go on and on. But let's do a little quiz here. When it comes to the work that lawyers do for free, pro bono work for lawyers do for people who can't afford it, how do you think we rate and compare to the general population when it comes to volunteer work? Do you think we do more, less, the same? It's a landslide. We win by a landslide. 3/4 of all lawyers today are doing some kind of pro bono work for those who can't afford it, and that's roughly 3 times the national average of volunteer work. When was the last time your accountant did your taxes for free or your mechanic repaired your car for free? But lawyers do it all the time. And I've been talking to my network brothers and sisters over the last few weeks preparing for this, and the amount of pro bono done by lawyers in general and by network lawyers is astounding. Unfortunately, today we need to do a little bit more, and that's why I'm here to speak. What is not pro bono? I've done a lot of pro bono work for that top category, especially the last couple of years. We sign retainer agreements and all that, and then they just don't pay us. So I guess that was pro bono. Your broke, deadbeat brother-in-law who can't keep a job and it keeps calling to get you to get him out of jail free. I've got several of those, actually. That's not pro bono. What is pro bono? Pro bono is what the American Bar Association tells us that we should do. We should do roughly 50 hours a year each, more if we can, for people of limited financial means. Why now? Why is this a big deal in 2013? The stats are astounding. 61 million people qualify for legal assistance. That's 10 million more than just a few years ago. Up to 80% of those who qualify for legal assistance, need legal help, have real legal cases and grievances, are turned away. That's over 1 million cases annually in 2012, 2013 being turned away for lack of resources. And unfortunately, at least in bigger firms, the average number of pro bono hours is going down a little bit. See if we can change that. Let's see some stats very quickly. It's kind of a busy slide, but it shows how many hours of pro bono the average lawyer is doing. And we can see on the left, well, let's start with the right. The right, a lot of lawyers are doing a lot of pro bono these days. But on the left, probably 60 to 70% are doing less than the 50 hours the ABA recommends. So we've got capacity. This is actually hot off the presses here. This is not part of my speech, but this just came out yesterday. The state of New York, lawyers from New York, you have new rules. The Supreme Court, the Chief Justice of your Supreme Court or your appellate division, after praising lawyers for selflessly providing millions of hours each year in pro bono service to the poor, said, the civil legal needs of low-income New Yorkers are enormous and continue to grow as a result of the uncertain economy. And thus, there is now going to be in New York, starting this week, a 50-hour recommended minimum of pro bono. Let's see who's doing the hours. The average number of hours of pro bono work by lawyers these days, and this is a slide, if you look at the green, it's a little busy, but the average lawyer is doing 42 hours. That's great. 42 hours of free professional help. There aren't many professions can say that. In private practice, the number is about 46. Corporate in-house lawyers, the number is about 23. I mean, not the in-house lawyers in this room, because I know it's a lot more. I'm talking about outside in-house lawyers elsewhere. The reality is that the central component of our legal system is equal access to justice. The laws are complex, the system is complex, and without lawyers, statistically, people just do not have access. Who are all these people who need our help? You recognize this character from the movie, deadbeats and freeloaders, is that what they all are? Yeah, some of them, but not all. A lot of these are well-meaning people who just need a hand to have their hand held through the legal system. 50 years ago, in the Supreme Court case of Gideon versus Wainwright, we learned that every individual is entitled to representation in a criminal case. That does not apply to civil cases. Most Americans don't realize you can have your home taken away, your livelihood taken away, your family taken away. You have no right to representation. Representation in the Gideon case does not apply to job loss, custody, spousal abuse, foreclosures, homelessness, loss of children, the most essential components of our livelihood, family, job, homes. We do not have a right to representation in those areas. Let me give you a couple of examples of what lawyers do when people do have representation. Walter Bloss was 89 years old. He lived here in Florida. He was served an eviction notice for the apartment he had lived in for 43 years, rent-controlled apartment, because he complained that he didn't have any running water. He went to court without a lawyer. The landlord had a lawyer. He was thrown out. A civil lawyer, like the network of trial law firms lawyers in this room, handled his appeal for free, got him his home back. Many of you may have seen this story from the New York Times just a few months ago. It is easy to tell who is going to win an eviction court. On one side of the room sit the tenants, men in work uniforms, mothers with children in secondhand coats, confused and crowded together on hard benches. On the other side are not the landlords, but their lawyers, dark suits doing crossword puzzles and joking with the bailiff as they casually wait for their cases to call. In housing courts today, 90% of all landlords have lawyers, 90% of all tenants do not, and 90% of the time the landlords win. That's just too coincidental. Let's give another example. Elderly Shenandoah County, Virginia woman needed money to repair her car. She took out a payday loan at interest of 200%. She made payments of $200 to $500 per month for 3 years out of her Social Security check for $624. At the end of that time, she still owed money. A network of trial law firms' lawyer came in, represented her pro bono, got the Virginia Supreme Court to change its predatory lending laws. Why are we wasting time talking about $624? There are lawyers in this room charge more than that per hour, but all she had to live was $624 and a lawyer. Let's talk about what we can do about it. Let's start with what in-house lawyers can do, what outside counsel can do to do a little bit more these days on top of all the great work that's already being done. I know there are perceived impediments for those of you who are in-house. Lots of times your companies don't have malpractice insurance. Sometimes you're admitted in states other than the state where you're now practicing. Albert Einstein once said 90% of success is just showing up. If you just show up to any legal aid society, any state, city bar association or state bar worth its salt, they take care of those problems immediately. Better yet, though, contact your lawyer. Contact your network of trial law firms, lawyer, and team up. We're doing this with a couple of clients right now, teaming up on pro bono projects. It is a great way to solidify a good attorney-client privilege relationship by working for a cause like that. How can outside firms support pro bono? How can we create a pro bono culture in our firms to make it a thing, an incentive to do so? We can first set hourly minimums. Our firm, we have a 25-hour minimum set by our own managing partner. Some people don't do it, and they don't get voted out of the partnership, but they don't. But actually, that's kind of low. I'm talking to some other network lawyers when preparing for this who have minimums much higher than that and have average donations of time much higher than that, upwards into the 3 figures, and they're doing just fine financially. Count hours, pro bono hours toward billing requirements. Every firm tells new recruits, we support pro bono. But if you tell your new recruits you do that and you don't count their pro bono hours toward their minimum requirements, we're not supporting it. Have staff people who are dedicated to help with pro bono cases. Advertise pro bono successes. In our firm, when we win a trial, we send all these emails around what a great result it was. We do the same thing, though, for pro bono. And then last but not least, kill 2 birds with 1 stone. Make it part of associate training. As was discussed this morning, when it's harder and harder for younger lawyers to get in the courtroom, this is an area where cases get to trial. The first case I ever tried, 9 months out of law school, is a case I handled pro bono. I had some partner supervision, of course, but I took a depo, I defended a depo, and then I tried the case, and I got a whopping $42,000 verdict. Thought it was great. I didn't even care if it was a pro bono case. I just wanted to get courtroom experience, but it helped someone who needed it. What are some areas of pro bono? You're saying, listen, aren't these all landlord, tenant, and child custody cases? That doesn't do much for me. There are so many areas where you can do pro bono work. Wills and trust, bankruptcy, consumer fraud, predatory lending, intellectual property. We have a younger associate in our intellectual property group. She's handling a federal court intellectual property pro bono case. It was a former retired professional athlete who came up with a social networking site. That's the word I'm looking for retired professional athletes down in their luck. And then some bad guys came in and misappropriated the site and such. So she's handling a first chair federal court case pro bono regarding intellectual property. Say I'm not a litigator. There's all kinds of transactional work non-litigators can do. You can work for nonprofits. You could do the taxes and such for the Legal Aid Society. You can work on their real estate issues, their financing issues, etc. You say, hey, I just don't have time to commit to someone for a whole year. These cases drag on forever. Not a problem. Every major metropolitan area has a federal pro bono project, and probably several others that I'm not even aware of, where they have limited representation opportunities for pro bono. You can handle one hearing. You prep for the hearing, you go argue that hearing for someone, and you're done. You argue and prepare a summary judgment motion, you're done. You go to a mediation, at the end of the day, you're done. And you might even try the case. Why should we do it? I've mentioned several reasons why today of all days we should try to do a little more pro bono. We should do it because we're lawyers. We do things, like I said, no one else can do and no one else will do these days. We can help people like no one else. It's the right thing to do. We are not service providers. We are not vendors. We are lawyers. And we all took an oath years ago when we thought we could change the world that said something very similar to this. This, I believe, is from Texas, but every state has an oath just like this, and we all swore something that said, I am a lawyer. I am entrusted to preserve and improve our legal system. A lawyer owes to the administration of justice personal dignity, integrity, and independence. A lawyer must always adhere to the highest principles of professionalism. My word is my bond. I am responsible to ensure access to competent representation regardless of wealth or position in life. And last but not least, we vowed I commit myself to an adequate and effective pro bono program. That oath we took doesn't say anything about profits per partner. It doesn't say anything about realization rates, and no matter how many times you read it, you will not find the word Serengeti anywhere in that statement. Thank you.